Hello, welcome to those of you who are joining this webinar on access to justice, tackling discrimination. We will wait for a few more seconds for people to enter into the webinar Zoom call. Okay, well, welcome to the third in the series of webinars on international human rights litigation, new frontiers and challenges, co-organized by Professor Philip Leach and Professor Başak Çalı. So today's webinar is on access to justice, tackling discrimination. My name is Diamond Ashiakbo. I'm Professor of Law at the University of Birmingham and also a member at Matrix Chambers. I'll very briefly introduce our panelists today and then hand over to, I think, Professor Çalı first to introduce the theme of today's webinar. So as I said, the series is co-organized by Professor Philip Leach, who's Professor of Human Rights at Law at Middlesex University, practicing human rights lawyer and member of Matrix Chambers. The first speaker will be Professor Başak Çalı, who's Professor of International Law and Head of Research at the Bonavero Institute of Human Rights at the University of Oxford. Professor Çalı holds a permanent visiting professorship at the I Court Centre for Excellence at the University of Copenhagen and is a fellow of the University of Essex Human Rights Centre and the Hertie School in Berlin. Her expertise concerns international law and human rights. She's published widely in the field of authority of international law, standards of review, relationship between international law, domestic law, European human rights, and UN human rights law. As legal practitioner, in addition, Professor Çalı is co-founder of the European Implementation Network, Europe's leading civil society organisation that advocates for the full and effective implementation of human rights judgments. She's acted as an expert of the European Convention on Human Rights since 2002 and has trained judges, prosecutors, lawyers and police officers in the implementation of the Convention across the Council of Europe. So I'm going to hand over now to Professor Çalı to introduce the main theme of this webinar on access to justice, tackling discrimination. She'll speak for a few minutes, and then we will have slightly longer presentations from Dr. Betül Durmaz of the Hertie School Centre for Fundamental Rights and Tamar Dekonosidi of Equality Now. So handing over to Professor Çalı. Oh, just before I do that, to let everybody know, there will be opportunity for the audience to ask questions, and I ask you if you could save your questions for the end when everyone's finished speaking and write your questions in the chat box and I'll read them out for the benefit of all audience members. And we aim to finish at exactly 2 o'clock or just a minute before 2 o'clock. Okay, so thank you, Professor Çalı.
Thank you very much, Diamond, for that kind introduction. So today's theme is access to justice and tackling discrimination. And the theme of this 4 series of webinars has always been to look at frontiers and challenges. I think in this field, we face a very long list of challenges, and I'm sure both of our speakers will also give us a good sense of where the frontiers are, both in the practice and the decisions that are coming out. But I would like to focus perhaps on a series of issues that is really worth reflecting on when we talk about challenges in this field. First, I think a point to underline is that there has been, especially in scholarship in anti-discrimination and equality, a new discussion as to whether the equality laws, the equality provisions, the equality treaties that we have devised in the past 40 or 50 years are really fit for purpose. So I know that this is not going to be the big focus of our discussion today, but I just want to situate it in this larger kind of debate about the success of the way that we have legalized anti-discrimination equality, and the successes, and how, to what extent it has been successful, has been subject to quite a lot of soul searching, especially in the academic literature and scholarship around anti-discrimination and equality. And of course, one of the key reasons for that is when we talk about anti-discrimination equality, we're not necessarily only talking about, we are of course talking about individuals and individual victims, but we often also talk about structural and historic forms of discrimination that certain groups in diverse societies have suffered. So the link between how to talk about an individual case against the backdrop of both historic and structural forms of inequalities is incredibly challenging. And to do so in a courtroom or before a United Nations treaty body is, I think, even all the more challenging. So I just want to place this in the broader context. But when we talk about the practicalities of litigating discrimination, if we do understand that a lot of most forms of discrimination are structural and have historical legacies that are attached to that, we also view and see a long list of difficulties, at least in international human rights law. And I know that our speakers will speak to these challenges, but of course the first one is standing and the victim status. I think this is a really important one because even though we have successful cases where people have successfully proven that they were victims, there's a wide majority of cases where we know that this has also not been successful. So I'm talking about the inadmissible or the silent cases that cannot even pass into this hurdle. The second set of challenges that comes in relation to litigation has to do with evidence and burden of proof, and also the shiftings of the burden of proof, and what kind of evidence we are addressing when we talk about these cases. For example, is historic discrimination a notorious fact? Or would the applicants have to prove that certain forms of discrimination is structural or historic? And what will they have to do it? This is a huge burden to put on an individual, to take on a whole society to be able to talk about these things. So what is the role of notorious facts doctrines and similar doctrines in this regard? And what is the balance between the individual and the authorities in showing proof of not individual suffering, but also structural suffering that informs the situation of a particular individual? And of course, the third set of challenges is about substance and merits. How would a court or a United Nations treaty body, or how would they decide that they have found discrimination? And what kind of discrimination? Is it multiple discrimination? Is it intersectional discrimination? Is it structural discrimination? Is it a one-off discrimination? And these terms are now really very much state of the art, but also equally challenging. And does it matter which ones of these do we use in our litigation strategies? I think they do matter, but of course they're very difficult to argue depending on which court we're dealing with. I think the fourth set of challenges also has to do with the law. As you know, especially in the European Court of Human Rights context, the anti-discrimination clause for many states is still not a standalone provision, but is accessory, so that there is an additional hurdle for individuals to show that they were discriminated in the context of exercising a certain right. Whereas in the United Nations human rights treaties, what we will call equality treaties, such as CEDAW or the CRPD or the CERD, this is not necessarily the case, that equality is a standalone concept which is infused in multiple provisions of these treaties. And of course, which treaties we use, which courts we use, significantly then matter what kind of outcomes we receive from litigation, and whether these are equality advancing outcomes or not. So there are some range of questions over there. And finally, perhaps we should think about remedies. Why do we engage in this type of litigation? And of course, a lot of individuals, for many individuals, it really matters that they're recognized and their claims are recognized and they're heard. But equality and anti-discrimination litigation should give us perhaps general remedies so that similarly situated people are not falling into the similar patterns of discrimination. And of course, this is an area where, in particular, international courts perhaps are not best situated to devise and advance or to enforce even these remedies. So we have a long range of sections, moments in the practice of litigation that I think we will we witness these challenges. And while some of these challenges may look very technical, we're also trying to move a very large mountain from one place to the other. And let me leave you with these broad reflections. And thank you very much.
Thank you very much, Professor Çalı. I now will move over to hear from Tamar Dekanod-Sizde, who is based at Equality Now. So Tamar is a human rights lawyer at Equality Now's regional representative in Eurasia. In this role, she leads the development and implementation of Equality Now's work to address violence and discrimination against women and girls in Eastern Europe, the Caucasus, and Central Asia. She's represented survivors of gender-based violence and other human rights violations in local, regional, and international courts and bodies such as European Court of Human Rights and CEDAW, securing outcomes that provided access to remedies for survivors and led to broader legal and policy changes. She's also drafted laws and legal amendments on equality, non-discrimination, and addressing violence, many of which have been adopted by authorities in the region. She's led to the creation of guidelines and training programs that have improved access to justice for survivors of sexual violence. Tamar studied at Tbilisi State University and also undertook and obtained an LLM in International Human Rights Law with distinction at the University of Essex. She has been Humphrey Fellow and International Visiting Scholar at American University Washington College of Law. And today, Tamar is going to talk to us about the use of equality law to tackle gender-based violence and domestic violence. And this is a question of this form of violence is not just a matter of human rights violations, but it can also be understood, conceptualized, and understood by the court, violence against women as discrimination. Thank you very much, Tamara.
Thanks a lot, and thank you so much for having me. I will be talking about the challenges of litigating discrimination against women before the European Court of Human Rights. Specifically, I will discuss how the court has approached examining discrimination in violence against women cases, specifically where its jurisprudence still falls short in recognizing the role of sex or gender-based discrimination in such cases. I will also highlight progress that has been made and outline the advocacy priorities to close these gaps. This is based on the cases I have been litigating at the European Court of Human Rights with the Georgian Young Lawyers Association, the European Human Rights Advocacy Center, and Equality Now, including through third-party interventions. I will also be happy to respond to any questions that concern the practicalities of taking the cases at the European Court to the European Court of Human Rights on such issues, such as identifying the cases, interacting with the survivors, exhaustion of domestic remedies, evidentiary issues, and so on. It is a long-standing principle in international human rights law that violence against women is a form of discrimination against women, and this has been established by CEDAW Committee's jurisprudence, the Istanbul Convention, the European Court of Human Rights, and so on. However, in some key areas, discrimination based on sex or gender in violence against women cases is still not treated with the same seriousness as discrimination based on race and sexual orientation. And this is the challenge we are aiming to resolve. For example, the court has rightly recognized that the state's failure to prevent and respond to domestic violence and killings as part of domestic violence constitutes discrimination. And this was established in cases like Opus versus Turkey, Tralize versus Georgia, AB versus Georgia, and so on. The remaining gaps are as follows. Rape and other forms of sexual violence still does not enjoy the same standards as other forms of violence against women. Namely, the failure to prevent and respond to sexual violence as it is done in relation to violence against domestic violence cases is not considered as a form of discrimination by the European Court. Another gap is not establishing the failing to investigate sexist or gender-based discriminatory motives of perpetrators as discrimination. And this is true in relation to all forms of violence against women, not only in cases of rape and other forms of sexual violence. By contrast, the court has been much clearer in cases involving racist or homophobic motives. For example, in cases of Nachova versus Bulgaria, BS versus Spain, Identoba versus Georgia, and so on, the court has found that a state's failure to investigate racist or homophobic discriminatory motives behind the acts of violence constituted discrimination. If this is not done, the court says that these crimes will be treated like ordinary crimes, not the aggravated ones. And this kind of indifference can amount to the authorities silently approving or even supporting such violence. The same, particularly about the motives of the perpetrator who commits violence against women, has not been ruled in cases of sexist violence against women, despite the fact that the court has quite extensive case law about discriminatory passivity of law enforcement authorities to respond to domestic violence and framing these systemic barriers as discrimination. That said, the court's case law is evolving on this specific matter of examining sexist motives of perpetrators. In A and B and others, and Gajdukovic versus Georgia and Gajdukovic versus Georgia that we litigated, we argued that not only the failure of authorities to protect women constituted discrimination, but also the authorities had to examine gender bias of investigators and prosecutors. And the court took this approach on board. The court held that the failure to investigate the discriminatory motive attitudes of law enforcement officials responding to domestic violence complaints constitutes a violation of Article 14 in conjunction with Article 2, which is the right to life, in conjunction with prohibition of discrimination. In Tralize versus Georgia, the court stressed the pressing need to examine whether police inaction was driven by gender-based discrimination, while in A and B versus Georgia, it similarly noted signs pointing to possible gender bias in law enforcement response, reinforcing the need for investigation of discriminatory motives. However, and this is a very important point, the focus is discriminatory motive and bias of state actors, of investigators, the police officers who failed to respond to the complaints on violence against women. And the focus is not on discriminatory motive, which is great when it comes to examining the bias of investigators and prosecutors who failed to respond to domestic authorities. But the court has yet to put focus on discriminatory motives of the perpetrator of violence against women. And such motives are intrinsic to violence against women. So to conclude, core challenges in strategic litigation and advocacy at the European Court of Human Rights on this matter are as follows. The court has to explicitly recognize that failure to prevent and respond to rape and other forms of sexual violence constitutes a form of discrimination against women, just as the court has done with domestic violence and killings of women as a result of domestic violence. And the second, the court should apply the same standards it uses for racist and homophobic violence to cases involving sexism and misogyny. The court should clearly state that failing to investigate sexist motives behind violence against women cases is a violation of the right to non-discrimination, and this should apply to all forms of violence against women, domestic violence, sexual violence, and femicide, the term the European Court has yet to officially recognize. We are continuing to raise this issue through ongoing litigation, third-party interventions, and advocacy at the local level and international mechanisms. And our goal is pushing for jurisprudence that fully reflects the lived realities of women and recognizes the structural discrimination embedded in all forms of gender-based violence against women. Thank you, and I am happy to respond to any questions that might arise.
Thank you so much, Tamar. So I will now hand over to Dr. Petul Durmaz. Dr. Durmaz is a postdoctoral researcher at the Center for Fundamental Rights at the Hertie School in Berlin. She's working on a project currently on deep impact through soft jurisprudence, the contribution of United Nations treaty body case law to the development of international human rights law. She's associate editor of the UN Human Rights Law module of Oxford Reports on International Law, and in that context has published 22 case reports from 7 United Nations treaty bodies on issues relating to transitional justice, sexual violence, children's rights, and discrimination based on ethnic origin and disability. Dr. Durmaz received her PhD in public law from Koch University with a thesis examining whether and how international human rights law reconciles children's rights with parental control rights. Before joining the Hertie School Center for Fundamental Rights, she worked in public international law at Koch University on projects engaged with the effect of human rights law on public international bodies, and the individual application of case law of Turkish Constitutional Court and the impact of the United Nations human rights treaties in Turkey. Generally, her research interests lie in UN human rights law, comparative international human rights law, international children's rights law, and Turkey's relationship with international human rights mechanisms. And today, Dr. Durmaz will talk about the role of UN treaty bodies, questions of standing, representation, in particular in relation to CEDAW and CERD. Thank you.
Thank you very much, Diamond, for this kind introduction. And also, I would like to thank, of course, to Matrix Chambers and Bonavero Institute of Human Rights for their kind invitation. And I'm delighted to speak on both substantive and procedural challenges and also opportunities that exist for non-discrimination litigation before the United Nations treaty bodies. And in my presentation, I will start with admissibility, focusing on standing and representation of victims, and then move to more substantive issues concerning the role of intersectional and multiple forms of discrimination, as well as the obligation to combat stereotypes. So let me begin with admissibility and the question of who has standing before the United Nations treaty bodies. So for the CERD, and this question, of course, like has, as Başak mentioned, because of fragmentation, this question has different answers with respect to different treaties. And for the CERD, this should include anyone experiencing discrimination on the basis of race, color, descent, or national or ethnic origin, as listed in Article 1 of the CERD. And in that direction, the CERD committee rejects applications that do not raise at least one of these grounds. For instance, in the past, it dismissed claims invoking religion-based discrimination or discrimination against foreigners in general. And a further obstacle for standing before the CERD committee is posed by the second and third paragraphs of Article 1 of the CERD, which exclude the issues of nationality and citizenship from the scope of the convention. However, starting from General Comment number 30 in 2004, the Third Committee has accepted that differential treatment based on citizenship or immigration status is also within the scope of the convention, and this interpretation was later consolidated in the high-profile case, interstate case between Qatar and United Arab Emirates. And when it comes to CEDAW, so CEDAW specifically addresses discrimination against women, which is less categorical compared to the language of the CERT. And this specificity raises the question of whether CEDAW can accommodate claims coming from individuals who do not identify as women. And a significant development in this regard is the case Madsen and others versus Canada, in which the CEDAW committee accepted claims from male descendants of an indigenous woman who had suffered gender-based discrimination in the past. And here the committee decided that the male applicants actually inherited this gender-based discrimination. And previously in MW versus Denmark, the committee accepted a boy child as a victim of discrimination. So the committee has so far relaxed victimhood requirements. And we observe a similar relaxation of victimhood requirements in the practice of the CRPD as well. In the case of Bellini versus Italy, the CRPD committee recognized a caretaker and a family member of a person with disability as a victim, even though she did not have any disabilities herself. Now, after these observations on standing, I would like to move to another interrelated issue, the representation of victims of discrimination. Here, I believe submissions by non-governmental organizations can prevent some obstacles, because states might argue, and they argue, that these organizations are not personally or directly affected by discriminatory measures. Thus, they lack standing before the committees. And for example, the Third Committee received such an argument from Germany in a hate speech case, TBB Berlin-Brandenburg versus Germany. And the committee ultimately dismissed this argument. But what was important for the committee were two factors. First, the nature of the organization's activities and purposes. And second, whether the individuals it represents, the organization represents, satisfy the victim requirement themselves. And for a successful litigation by non-governmental organizations, it is crucial whether they act on behalf of the victims, who may be their members, or if they claim to be victims themselves. So the CEDAW committee, for instance, decided in a case against Poland, a Polish Society of Anti-Discrimination Law versus Poland case in 2019, that an organization can represent its members as victims if it provides their names to the committee, and if it provides consent statements to be represented before the committee. And in the alternative, if the organization acts under its own name before the committee, it must have done so before the domestic authorities as well. So there should be a direct link between the organization's previous submissions at the domestic level and those before this CEDAW committee. And if there's no direct link, then this will be deemed inadmissible. After these admissibility related issues, I would like to turn to more substantive issues, and I would like to highlight first the central role of intersectional and multiple forms of discrimination. And as we see when we look at the practice of the United Nations treaty bodies, we see that both concepts have long been actually integral to the treaty body's practice. An important example is Yacker versus France. There, the Human Rights Committee decided that the French prohibition on the full face veil in public places constituted discrimination based on both religion and gender. And a more recent example is CEDAW Committee's decision from last year regarding the mass forced sterilization of indigenous women in Peru. And there the committee identified that the case formed an intersectional discrimination based on sex, gender, rural origins, and also socioeconomic status. And I think this widespread recognition of intersectionality and multiple forms of discrimination across different treaty bodies offers significant litigation opportunities, especially considering that the European Court of Human Rights has lacked in acknowledging these forms of discrimination, and I think it has a scarce case law recognizing intersectionality or multiple forms of discrimination. And on substantive issues, my final point concerns stereotypes and the related concepts of bias and prejudice. These ideas have a textual basis. Article 5 of CEDAW and Article 8 of the CRPD impose obligations to take appropriate measures to combat these phenomena. And both provisions, Article 5 and Article 8, are justiciable before their respective committees. And the CRPD committee, for instance, addressed stereotypes and prejudice against persons with intellectual disabilities in the field of education, in the case Garcia Vara versus Mexico. And I think when I look at the practice of the United Nations treaty bodies, I see that CEDAW committee has provided the most comprehensive engagement with stereotypes so far. In individual communications, the committee has highlighted stereotypical conceptions across a wide range of issues, including women's reproductive role, victims of rape and sexual violence, victims of domestic violence, and also extramarital relations between men and women. And in many of these cases, the committee has found separate violations of Article 5 of CEDAW. And CEDAW committee's engagement with gender-based stereotypes also informs its subsidiary role in relation to the decisions of domestic courts, and that's why it's also very notable. And it's a general principle for all treaty bodies that they do not consider themselves competent to review the decisions of domestic courts unless those decisions are, I quote, clearly arbitrary or amount to a denial of justice. However, for the CEDAW committee, in some cases, this exception extends to domestic court decisions that are biased or rooted in gender-based stereotypes. So with this final point, I would like to conclude my presentation for now, but I'm open. I will be happy to receive questions, and I look forward to the discussion. Thank you very much.
Thank you. Thank you so much, Betul. So we actually have a number of questions which are being put into the chat box, and a few of them have been answered by Tamar, and I'll copy and paste them so everybody can see. But one initial question which was addressed to Professor Çalı was asking for clarification on the burden of proof, because you mentioned that in passing, and how that can be shifted in terms of, how the burden of proof operates normally, and then how it might be shifted.
So perhaps I will give this question back to our two main speakers, because the tests that are employed in different international courts and bodies are not necessarily fully coherent. So perhaps Tamar, you could say a few words about the European Court, and maybe Betul can also make some observations on the UN treaty bodies. This comes back to my original point that there are very significant differences of handling anti-discrimination cases across international courts and bodies.
Yes, Tamar?
Yeah, about the issue of burden of proof is a very significant one, especially when it comes to cases of violence against women, especially the issues of sexual violence. And we are seeing a lot of backlash about when it comes to improving laws on sexual violence, while some lawyers are stating that if you introduce a consent-based definition of rape, the burden of proof will fall on the defendant rather than on the prosecutor. And that is used as an argument to oppose the laws that are in compliance with international human rights standards and international criminal law. When it comes to sexual violence, the burden of proof does not change. The same standards apply as in all the other criminal cases. The burden of proof is the onus is on the perpetrator rather than on the defendant. But when it comes to cases of sexual harassment, this is where we see the shift of the burden of proof, and such issues are included in the national legislation as well. For example, the law on prohibition of all forms of discrimination against women. Sexual violence is an act which is not serious enough to reach the level of criminal responsibility. Therefore, shifting the burden of proof from the complainant to the other party also has nothing to do with the violation of the principles of the criminal law, because sexual harassment is not a crime. So I would say that when it comes to the violations committed against women, sexual harassment is the example where the burden of proof shifts. In all the other forms of violence against women, especially the ones that are included in the criminal code, the same standards apply as with other forms of violence.
Betul, thank you.
Yes, so for the United Nations treaty bodies, of course, the Human Rights Committee has long established that intent is not an important criterion to establish the prima facie discrimination before the Human Rights Committee. So it's in Suminek versus Czech Republic case, I think. And from now on, I think the Human Rights Committee and also the other committees as well, they do not require intent. So this is something important, I think, in terms of the requirements of proving prima facie discrimination. And also, I would like to maybe mention one important difference that especially the discrimination treaties at the United Nations level from the ECHR, is that these treaties are formulated quite differently. So they are actually they involve really concrete obligations to combat discriminatory practices and to ensure equality both in public space and also in private space. So therefore, I think this also has influenced the reasoning of the committees, because they drive their interpretations from those concrete obligations in kind of stipulated in different treaties and different treaty provisions. So the starting point is actually obligation for United Nations treaty bodies, for CEDAW, for CERT, and also for the CRPD.
Thank you. So we have a question in the chat about, okay, it's directed at Betul. Thank you for your presentation. Is the separation between multiple discrimination and intersectional discrimination clear in the jurisprudence of the treaty bodies you mentioned? These two types are differentiated in scholarship, and it's argued by some that multiple discrimination is actually not a very useful category as opposed to intersectional discrimination. And the CESCR has so far only reported on intersectional discrimination in its jurisprudence, for instance.
Yeah, I mean, I think in individual communications, that distinction is not clear because for the CEDAW committee, for instance, it is always intersectional discrimination. But when you look at the language of Human Rights Committee, it uses like discrimination based on, gender and religion. So it does not really specify whether it is intersectional or multiple, but when you read the statement, you understand that it is actually a multiple discrimination because it's based on X and Y. But we have a clear definition, the clear differentiation actually between these two concepts in the CRPD committee's general comments, I think, on equality and non-discrimination. There, the committee defines both of these concepts and point out their differences. Yeah, but in the case law, I think this differentiation is not that clear.
Okay. There are a couple of questions which Tamar has answered. I was wondering, Tamar, if you were asked about the cases you cited in your presentations, wondering if you could paste them into the chat, because I'm not able to do that, so that everybody has access to the names of the cases you mentioned, the ones involving Georgia and femicide.
Yeah, I did paste them. I can see them, but I could do it again if it's not visible. But yeah.
Into the webinar chat to the right of the screen.
Not in the answered questions.
Q&A chat.
Yeah. Yeah, I will do that.
And then there was also a question addressed to you. I'll just read it out. It was, in light of the wave of threats, especially by states in Eastern and Central Europe, to withdraw from the Istanbul Convention and actual withdrawal in the case of Turkey, what would you say about the court's current ability to accept cases and especially implements its judgments related to domestic violence and violence against women and femicides more generally?
Yeah, I also responded to this question in the chat, and I could, of course, reiterate my thoughts on that. Of course, it's very unfortunate that there's backlash against Istanbul Convention in some countries, and the withdrawal from the Istanbul Convention or failing to comply with its provisions could lead to deterioration of the protection of human rights of women. The good thing, though, is that even if a state is not a party of the Istanbul Convention, on the very specific issues that are included in the convention, an individual can still take applications to the European Court of Human Rights, and the European Court will rule on these matters. However, the negative side when it comes to withdrawing from the Istanbul Convention is that the monitoring body of the convention, GREVIO, will no more have the opportunity to comprehensively assess how the country complies with its obligations to combat violence against women, and not all the cases, all the issues that are included in the Istanbul Convention can be taken to the European Court of Human Rights, because the survivors might experience a number of obstacles during litigation and accessing the court. If they manage to reach the court and if the cases are found admissible, the court will examine violations that are included in the Istanbul Convention, but in the framework of the European Convention on Human Rights.
Thank you. I think the other questions have been answered and the answer should be visible to all attendees. Başak, Betul, Tamar, do you have any additional comments to make, or even cross-referencing to what another panel member has said?
I would be very keen to hear of Tamar's experience, as you were highlighting towards the end of your presentation, Tamar, about the actual practice of working with the victims and how you're kind of handling that difficult process of litigation, as well as you're doing your legal advocacy. Perhaps you could reflect on that further.
When it comes to litigating cases of violence against women, the lawyer who is handling such cases should be aware of the fact that violence against women, especially sexual violence and other grave forms of violence, could be extremely traumatic for the victim, and the lawyer who's taking the case to the European Court should take every possible measure not to re-traumatize the survivor and explain to the survivor any steps and expectations that they can have from the European Court of Human Rights. The awareness about the procedures of the court might not be very high, especially survivors who do not have legal background. So it's crucial for them to understand whether they would go through any additional potentially traumatizing procedures to take the case to the European Court. For example, the European Court has very strict admissibility criteria, and one of those criteria is that you need to exhaust domestic remedies. You need to exhaust all domestic remedies that are relevant to the case. This is a very strict requirement, and failure to comply this requirement will render the case inadmissible. What it might mean for the lawyer and for the survivor is that the survivor might be subjected to additional investigative measures that have not been undertaken in the case locally for the case to be to make the case admissible for the purposes of the litigation of the European Court. Also, it is extremely important to understand that there might be grave violations of women's rights that could make potentially strategic cases at the European Court, but when it comes to violence against women, survivors very often are subjected to multiple pressures, pressure from their families, pressure from the community, pressure from the perpetrators to withdraw their cases, not to follow through the litigation process. And because violence against women is not just a human rights violation, it is deeply entrenched in social and cultural factors, and therefore the pressure that we have in patriarchy against women is especially heightened when it comes to survivors coming forward, and that could also be one of the issues that lawyers need to take into account when they are trying to select a case. Another issue in small countries like Georgia and some of the other countries that might arise is that even if you preserve the anonymity of the survivor while sending the case to the European Court, the survivor might still not be anonymous because the fact of the case might be known to but might be known by the community, and the survivor might face repercussions as a result of litigation at the European Court, and the lawyer might not be the best placed to protect the survivor from these negative consequences, which is also one of the considerations that lawyers need to have.
Thank you for that. We have a question in the question answer box, which is for Professor Başak Çalı. Is there any literature you would recommend reading to further explore equality laws and treaties not being fit for purpose in international law?
Thank you. Thank you for that question. So there is a special issue actually that is just coming up in the German Law Journal. So it will be the next upcoming issue where we invited a group of scholars to reflect on these questions, and you know, the discrepancy between having very deep inequalities and where the law stands in relation to addressing these things. So that will be the upcoming special issue of the German Law Journal. I will invite you to perhaps take a look at that. There will be a collection of papers, but also in particular my colleague at the University of Oxford, for example, Shreya Atri, in her work on equality law and whether it has reached an impasse and how to think about that productively, it would be also, I think, a scholar to read she's also part of this special issue of the German Law Journal. So I would definitely recommend those discussions.
Thank you. We have a question actually from Professor Philip Leach, which is, do the panelists see much potential in Protocol 12 to the European Convention on Human Rights? How could it be invoked to better effect?
Well, I think it is a great question because Protocol 12 provides much broader protection from discrimination than Article 14, which always needs to be taken into account in conjunction with other articles of the European Convention of Human Rights. When it comes to cases of discrimination against women, in my litigation practice, I have not yet identified the need for invoking Protocol 12 because referring to Article 14 in conjunction with other articles of the convention was insufficient. However, I think since there are some cases of violence against women where the court is reluctant to establish discrimination, reluctant to rely on Article 14, for example, cases of sexual violence, it might be great to try and litigate cases based on Protocol 12 to see whether the court will take some other approach. In cases where the court fails to rely on Article 14, despite the fact that the applicants raise it.
I mean, maybe I would also take a different kind of route in answering this, because of the lack of enough ratifications of this. I think we are kind of a little stuck with how far we can push the Protocol 12. And one other area, and I think we would want perhaps the court to engage more closely, is exactly the United Nations Human Rights Equality Treaties that are pretty much universally ratified by the member states of the Council of Europe, which opens up a really important and interesting technical legal question. So if all the members have ratified another treaty, so we're not, with almost no exception, then what is the role of what we call the equality treaties, like the CERD and the CEDAW and the CRPD, in the interpretation of the convention? So perhaps if we have limitations around the protocol, this could be another way of getting the European Court of Human Rights to think a little bit more broadly, not because it's perhaps a good idea, but also because all of the other states have established and committed to much broader obligations. There is some not very positive signs in some of the case law of the European Court of Human Rights when it, for example, refers to the Convention on the Rights of Persons with Disabilities. Instead of saying that all member states have ratified it and therefore it's important, the court at times refers to the lack of effective implementation of the CRPD as a reason for not taking it into account. And I think this is a very difficult position then, to say that because these treaties are not very well implemented in the national contexts, that they may not be a source of consensus-driven interpretation. I think these are areas that we need to, I think, tease out a bit. And going back to the question by the previous person, I think the challenges we see most with the equality laws really are exacerbated by the structure of the European Convention on Human Rights, whereas we have, as I think Dr. Durmuş highlighted, a much more promising venue with the UN human rights treaties, but they are not justiciable, obviously, before courts, but before treaty bodies whose decisions are not expressly binding.
So we have a question which is more about the UN instruments. Are there any measures supporting women suffering from dowry abuse and abuse more broadly, in particular with respect to employment, access to employment. I suppose that is linking the question of remedying dowry abuse generally, but also linking that to the question of discrimination with regard to the labour market. I don't know if anyone would have anything to say about that, perhaps the dowry abuse as discrimination question.
I mean, maybe I can jump in. I mean, based on our research on individual communications, I think the CEDAW committee's role in addressing economic inequalities is kind of narrower, I think, compared to its jurisprudence so far on domestic violence or on rape, sexual violence, and also reproductive rights. I think that area is still developing, and I think there's quite some potential there, but I think we haven't so far, I think, observed many cases in those issues. But there are not access to employment, but there are some cases concerning discrimination in the workplace, especially in the termination of labor contracts. Actually, it's as a case against Turkey, our RKB versus Turkey. There, the applicant's labor contract was terminated because her extramarital relationships with another coworker. And there actually the CERT committee identifies gender-based stereotypes in the decisions of the domestic courts and finds a violation. And there is another decision against Tanzania concerning the right to inheritance of women. Yeah, so that could be also a source to look at, but I don't think we have like specific cases on dowry and yeah, and access to employment.
Okay. And a final question, which I mean, I think it touches on what you've just been talking about, Betul, about stereotypes. It's a question about age discrimination and how that might link with sexual violence, but there's age discrimination as a freestanding issue. And I suppose the question would be, to what extent is that being tackled under the sort of broader umbrella of with regard to the UN treaty provisions on discrimination?
I think age is a recognized ground, I think, in almost all discrimination clauses of the United Nations treaty bodies. And of course, like we have a separate convention on the rights of the child, which has also a broad non-discrimination clause. So far, I think in individual communications, there are some cases concerning rape and sexual violence suffered by children. So there, of course, like you see some approaches that take into account intersectionality, intersectional discrimination based on age and also gender. So I think there is one case against Peru it's a recent case of the Committee on the Rights of the Child. So I'm not sure right now whether like the committee uses the term intersectionality or multiple discrimination, but it's also, I think, as far as I remember, the committee finds a violation and evaluates, of course, sexual violence experienced by the applicant as a form of gender-based discrimination.
Thank you. Thank you so much. I think it's time to wrap up. So I just remains for me to say thank you so much again to Professor Çalı and Professor Leach for organising this webinar series, and for Professor Çalı for introducing the overall theme today's Access to Justice, Tackling Discrimination. And in particular, thanks to our other two panellists, Tamar Dekanozidze and Dr. Betul Durmuş. Thank you so much. And just remind participants that there's the final webinar of this series will be on the 21st of May at 5 p.m. and that's on human rights remedies, trends and trajectories. So thank you very much. Goodbye.